My name is Bethany Davis Knoll. I'm the Executive Director at the State Energy and Environmental Impact Center at NYU School of Law, where I also teach. We'll be talking today about the Supreme Court with top appellate lawyers from 4 states and Kirti Datla from Earth Justice as moderator. I will start with intros and then I'll turn it over to Kirti to lead the discussion. I'm going to do the intros in alphabetical order by last name for maximum fairness. Ben Gutman is Oregon's Solicitor General. He previously served as Chief Administrative Judge at the United States Merit Systems Protection Board, which adjudicates civil service appeals by federal employees. He also has held several other public service positions, including Deputy Solicitor General for the state of New York. Ben graduated from Yale College and Yale Law School, and he clerked for Judge David Ebell on the 10th Circuit. Mithun Mansinghani serves as Solicitor General for the state of Oklahoma. He was appointed by Attorney General Mike Hunter in 2017 after serving for the prior 2 years as Deputy Solicitor General. Prior to joining the Oklahoma Attorney General's office, he was a lawyer for Gibson, Dunn and Crutcher in D.C., and he served as a law clerk to the Honorable Jerry E. Smith on the United States Court of Appeals for the 5th Circuit. He received his bachelor's degree magna cum laude in both political science and policy studies from Rice University, and a law degree with honors from Harvard Law School, where he served as editor of the Harvard Law Review. Lindsay See is the Solicitor General for West Virginia. Her work focuses on regulatory and administrative law issues, as well as leading and working with multi-state coalitions on a variety of national issues and top appellate work for West Virginia. Lindsay clerked for the Honorable Thomas B. Griffith on the D.C. Circuit and spent several years practicing appellate and administrative law with Gibson, Dunn and Crutcher in D.C. as well. She graduated magna cum laude from Harvard Law School, where she served as executive editor of the Harvard Law Review. She received her BA from Patrick Henry College of Purcellville, Virginia, where she graduated summa cum laude with highest honors in the major. Stephen Wu is the Deputy Solicitor General in the New York State Office of the Attorney General. Before joining the Attorney General's office, he was an associate at the Supreme Court and appellate practice of the law firm Aiken Gump in D.C., and a law clerk to Judge Diana Gribbin-Motz on the U.S. Court of Appeals for the 4th Circuit. He was a graduate of Harvard College and Yale Law School. Kirti Datla is Earth Justice's Director of Strategic Legal Advocacy. Prior to joining Earth Justice, Kirti worked in the Supreme Court and appellate practice at Hogan Lovells, and earlier in her career, she was attorney advisor in the U.S. Department of Justice's Office of Legal Counsel, as well as a law clerk to Associate Justice Sonia Sotomayor in the U.S. Supreme Court, Judge Jeffrey Sutton of the U.S. Court of Appeals for the 6th Circuit, and Judge Amol Thapar, then in the District Court of the Eastern District of Kentucky, now on the 6th Circuit. She received her BA in Environmental Engineering from Rice University and her law degree from NYU School of Law right here. Before I turn it over to Kirti, I will say that I am so grateful to the State and Local Legal Center for co-sponsoring this event with us and for NAG's support in getting the word out. CLE materials are in the chat, and I'll be dropping links to the SCOTUS blog pages when the speakers mention different cases. And we will be announcing a CLE attendance code. Please keep track of this, as you'll need it to certify your attendance for CLE credit. And now I'll turn it over to Kirti. Thank you, everybody. Thanks for being here.
Thanks, Bethany, and thank you to our panelists who we're so lucky to have here talking about the Supreme Court's docket and in particular how it affects states in the areas of environmental and administrative law. So let's dive right in. This past term, or I guess it's still the October 2020 term, has been filled with cases that will shape how the states legislate and litigate in various areas, ranging from religious liberty to voting rights, to takings law. And so I'm curious what each of you thinks the most, important or biggest case will be from this past term in terms of the impact that it'll have on the states. And why don't we start with Ben, and then each of our panelists can take a turn.
Sure. Well, I thought I'd talk about Penny's Pipeline Company versus New Jersey. And I may be biased in thinking that it's a particularly important case because I worked on a 19-state amicus brief in the case, but I do think it will have a significant impact going forward. So Penny's was about the intersection between state sovereign immunity and eminent domain. Excuse me. Under the Natural Gas Act, a private company that's building a gas pipeline can acquire the rights of way that it needs to build the pipeline by exercising eminent domain authority in federal court. And in other words, the statute delegates the federal government's eminent domain authority to the private company that's building the gas pipeline. So that's all well and good, but what happens when the pipeline crosses state lands? Normally, the 11th Amendment bars suits against unconsenting states. And so the question here was, does it bar an out-of-state company from suing the state to take its property through eminent domain in federal court? And in Penny's, the Supreme Court said, no, the 11th Amendment does not bar this suit. It was a 5-4 decision that scrambled the usual ideological lines. The majority opinion was by the Chief Justice, joined by Alito and Kavanaugh on the right, and Breyer and Sotomayor on the left. The dissent was Thomas, Gorsuch, Barrett, and Kagan. And what the majority said here is that the states, we know that the states consented to being sued by the federal government as part of the plan of the convention when they adopted the Constitution. And it's also long been understood that the government can delegate its eminent domain authority to a private party to construct public works. Putting those two principles together, the majority said, therefore, the states implicitly consented to being sued by private parties exercising the federal eminent domain power when they ratified the Constitution. Obviously, that has a direct impact on states because it means that private parties can sue to take state lands to build the gas pipeline, and there's some other statutes that provide similar authority in other contexts. But I think it will also be interesting to see how far this delegation theory goes. Can Congress get around other 11th Amendment limits in situations where the court has said that private parties can't sue the states directly by delegating to a private party the federal government's authority to sue a state? And I guess we will have to wait and see if that happens.
Thanks, Ben. Nitin, do you want to go next?
Sure. So I think one of the most significant decisions for state and local entities this term was the Cedar Point decision, Cedar Point Nursery v. Hasid. This was, unlike Ben's case, one that did fall cleanly on ideological lines, a 6-3 decision written by the Chief Justice. One of the few decisions actually this term that fell under those clean ideological lines, I think, along with the Brnovich decision. And this one was also related to takings. It was about a California law that required farms to allow union organizers onto their property to speak and organize farm workers during certain hours of the day for certain days of the year. And I'll also confess my bias because Oklahoma led one of the multi-state amicus briefs in this case. The court held that it was a per se taking for the California law to do that, which means that it requires just compensation, because the law forced property owners to grant an easement onto their property, the functional grant to an easement onto their property, because it forced them to allow people onto their property. And one of the core rights of property is the right to exclude. And the court said if the government wants to take that right away from owners, it has to pay for it. This is a potentially significant decision. It's like with what Ben said, it remains to be seen. But it makes it more likely that local and state regulations that impinge on property rights will require compensation to the property owner, which will force state and local governments to bear the costs of their regulations rather than imposing those costs on individual property owners, and the society as a whole will bear those costs rather than individual property owners. And when state and local entities have to weigh the costs and benefits of their regulation, they may end up crafting their regulations more narrowly or decide not to regulate at all. So this might have a significant impact on property regulation, and especially when it comes to state and local governments with respect to the takings clause.
Okay, great, thanks. So we have the 11th Amendment, we have takings. Lindsay, what do you have for us?
All right. Well, I'm going to take us in a little bit of a different direction. I'd like to talk a little bit about Fulton versus City of Philadelphia. And This one, just to give a snapshot of the case, it involved the City of Philadelphia's contract with various entities to help with placing children in foster care. Significant portion of that contractual relationship involved certifying families. And the Catholic Social Services have been working with the City of Philadelphia for decades, but as a matter of conscience, CSS will not certify any unmarried couples or any same-sex couples, whether married or not. So we don't have nearly enough time to get into the weeds of this decision. Suffice it to say there were many decisions in this one with justices taking different views. But the essential holding is that the city violated CSS's religious rights. And it looked at this question of whether Employment Division versus Smith applies. And the court had taken the case, and there was a lot of thought that maybe the court would be making a major move to overrule or to reaffirm Smith. But instead it said that this case didn't even implicate it at all, because in this particular circumstance, the city was able to give specific exemptions. So the court held this was not a neutral and generally applicable law, therefore it was outside Smith. And one of the reasons I think that this is an important case to look at is because this is the latest in a series of cases we've seen over the last several terms that can be described as this case only, maybe, where we think the court might be taking a bigger issue, but instead focuses on the specific facts of that case. And I think that's going to be really interesting for us to see when it comes to state and local laws and policies and how they'll be upheld or not going forward. Certainly in this particular context of anti-discrimination laws and religious liberty. But I think we also may see this more when it comes to COVID. For instance, there's a question of what happens in the vaccine passport context, where the issue is the circumstances in which a private business can or cannot exclude entry or services to anyone. So these are really important issues, and we have a series of cases where the court has said, here are the particular factors here, and has really left us in some ways on our own to figure out how it does or doesn't apply to these bigger issues. So I think there's a lot that's been raised here, and the answer from Fulton is still we don't know the answers.
Thanks, Lindsay. Stephen, why don't you finish this off?
Sure. So I thought I would discuss the BP versus Mayor and City Council of Baltimore case, which is technically limited to a very narrow question of appellate jurisdiction, but I think does have broader implications for federalism and the states. The technical issue in this case was about what's reviewable in an appeal from a remand order, which the district court sends a case that was removed from state court to federal court back to state court. Those orders typically aren't appealable at all, except on the limited grounds of what are called civil rights or federal officer removal, which are specifically identified in the statute. And the question in this case was, when removal was based on one of those two grounds and an order is issued remanding it to state court, does an appeal from that order cover only the civil rights and federal officer grounds, or does it extend to every ground for removal that was articulated by the defendant, including grounds that wouldn't independently support removal in the first instance? And the Supreme Court held that an appellate court could review every single ground for removal, wasn't limited to federal officer or civil rights removal, and in particular opened the door for defendants to argue federal question removal, saying that federal law should govern what was originally a state law dispute. Now that's a very technical ruling, but I think it matters for the states for two reasons. One is for the subject matter of this particular dispute, and then the second is a little broader. This case is one of several where states and localities have brought suits under state law or state common law against fossil fuel producers because of their contribution to climate change. And I think one of the major defenses that the fossil fuel producers have had is to say that federal law preempts or otherwise bars these challenges. Now, before BP versus Baltimore, those cases might have been removed to federal district court, but then if they were sent back to state court, that would have been at the end of the matter. And so a fairly limited disruption to the state's decision to sue in state court. But now that the Supreme Court has opened up the grounds for appeal from those orders, I think we'll see the intersection of federal law and state law being resolved by the federal courts much more in the first instance than by the state court. And that, I think, will have a significant effect on how those specific cases proceed. But I think more generally, we will see defendants feeling freer to remove cases to federal court and then having greater power under this decision to keep those cases in federal court, including through the appeals. As I think many of us have seen in our own practice, states bring enforcement actions all the time in state court. And it's very common for defendants to try to go to federal court on some federal question or preemption ground. And again, traditionally, that disruption has been fairly limited because you get a district court remand order and then you're back in state court and your foot is on the gas pedal. But now if things can drag out a little bit, I think that delay will start having implications to how state enforcement actions are able to proceed and might affect where and when states decide to bring lawsuits in state court as well.
Thanks, Stephen. So each of the 4 cases that our panelists just spoke about came to the court through its certiorari docket, which is, the normal process where a lower court hears the decision and somebody asks the court to take it up and to issue a final decision. But recently the court's heard a number of cases on its original jurisdiction docket, which are cases that come directly to the court. And Bloomberg Law recently published an interesting report noting that as the climate changes, the court might hear more of these disputes because one area that they often hear these cases in involves disputes over water rights, which might be more common in the future. So Mithun, I'm wondering if you could talk to us a little bit about the kinds of cases that the court has been hearing under its original jurisdiction docket, and also whether you see any trends that might tell us what you think the court might do in the future.
Yeah, so the original jurisdiction docket is certainly one that flies under the radar, but not in the shadows. We'll talk about the shadow docket separately. And this is a docket that's comprised generally of suits between states. So under the Constitution and statutes, the Supreme Court has jurisdiction over suits between 2 states. And the statute says the court shall have jurisdiction, but over the years, the Supreme Court has interpreted their exercise of that jurisdiction as discretionary. And so what happens is that a state will file a bill of complaint against another state, and then the Supreme Court will decide whether or not to grant that leave to file a bill of complaint against another state. In other words, accept original jurisdiction. And then if the court agrees, robocall. I'm sure we're all as states working on robocalls, by the way. So if the court agrees and the case involves quite a bit of fact finding, because remember, this is originally at the Supreme Court, there's no lower court trial to deal with, it's oftentimes assigns the case to a special master. Or in the case of water rights cases, oftentimes what's called a river master, which definitely should be people's life goals to be the river master one day. And indeed, both of the original jurisdiction cases this past term involved water disputes. One, Texas v. New Mexico, about whether New Mexico gets credit for evaporated water stored along the Pecos River, stored at Texas's request. And the other one, maybe a more significant one that people had heard about, Florida v. Georgia, which was a long-running dispute between those 2 states, pitting Georgia agricultural water users against Florida oyster fishermen, who were alleging that the overuse of water in Georgia was jeopardizing the oyster fisheries in Florida from the Apalachicola River Basin. It's not the first weird name I'm going to pronounce today. And the court ultimately ended up siding with Georgia, saying that Florida hadn't adequately proven causation there. But at the same time, there were some more high-profile cases that were denied original jurisdiction. So, probably the most high-profile one was Texas's lawsuit against Pennsylvania, Georgia, and other states on the 2020 election, but also Texas's lawsuit against California for California imposing a ban on state-funded travel to Texas, and a New Hampshire lawsuit against Massachusetts, where Massachusetts was attempting to basically tax the income of remote workers who are working in New Hampshire, I guess, for Massachusetts companies. The types of things that have been in the past part of the original jurisdiction docket: tax disputes, interstate commerce disputes, pollution, border disputes. But really, the court's docket has been primarily focused, as Kirti mentioned, on water disputes, and maybe those will become more common. I think even the last original jurisdiction case to be argued at the U.S. Supreme Court, the last one I can remember was way back in 2017. Again, a water dispute, Texas versus New Mexico and Colorado. Next term, we do have another original jurisdiction case, and that would be Mississippi versus Tennessee, another water dispute. This one not over a river, so I don't know if there will be a river master. It's about groundwater pumping in Mississippi. And then another case that has been granted original jurisdiction that all of us are involved in. It's the World versus Delaware, And this is a dispute about unclaimed property and MoneyGram, and whether MoneyGram, which is incorporated in Delaware, gets to escheat all the unclaimed property from MoneyGram in Delaware, or whether instead should go into the unclaimed property systems of the several states. That one was granted original jurisdiction, but as I mentioned, then it was referred to a special master, and that was back in 2016, and the special master just issued his report this year. And so it takes a while, like many other cases, to progress through the system.
Thanks, Vipin. So if you are one of those people who spends their Monday mornings watching the Supreme Court's order list and noting who's voted to take which case, you might notice something interesting happening in the original jurisdiction petitions, which Mithun mentioned. The court has to date interpreted its ability to have discretion whether to take a case or not. But Lindsay, not to paint you as one of those Monday morning people, but maybe you could tell us a little bit about what Justice Thomas and Justice Alito think of the court's jurisdiction in these cases.
Certainly, and Kirti, I'm definitely one of those Monday morning people. I would venture a guess everyone on this panel, and a good chunk of our participants are too. But you're right. This is a really interesting trend we're starting to see. As Mithun mentioned, many of the cases where the court exercises original jurisdiction involve water rights, and we're seeing some different forms of environmental cases. But outside of that context, the court has held for decades now that this is discretionary review. But we're seeing Justices Thomas and Alito who are staking out increasingly stronger positions against that. In a case in 2016 and 2020, Alito and Thomas dissented from decisions not to take up these cases and said the court likely does not have discretion not to exercise review. In Texas versus California, not the one we'll talk about later, but the one Mithun mentioned about travel restrictions, just this last term, we have the same two justices who expanded in a 10-page opinion and said, we as a court definitely do not have discretion not to take these cases. And these two justices are not alone. Justices Stevens and White have adopted similar views when they were on the court, but we're certainly nowhere to 4 justices who have adopted this. And essentially what their argument turns on is, what does shall mean? In both Article 3 and in statutory law, says that the Supreme Court shall have original and exclusive jurisdiction in state v. state cases. So the question is, does that mean that the Supreme Court must take every case involving these states, or can the court treat it like its certiorari docket and exercise this discretion? In these two justices' view, shall means shall. The court does not have this discretion. And part of the logic behind this is that because the Supreme Court has both original and exclusive jurisdiction in these cases, if the Supreme Court doesn't take them up, there's not another forum for them. And this could be seen as a pretty odd result, because you can imagine that cases involving one state or the other could involve some of the most sensitive and important issues facing the country today. So on their view, it's a somewhat odd result to say that there would be no forum for these at all. Now, the arguments to the contrary are that there are other ways that states can get into court, and that there's more administrative or practical concerns. There may be too many of these cases for the court to take all of them up. So it's an interesting issue. We're certainly seeing Justices Thomas and Alito becoming more forceful about it. Right now, we don't seem to have other justices who are signing on board. And I think what that means for states going forward in litigation is it leads to some more creative thinking and litigating when it comes to how do states get into court in these cases, if they know that the Supreme Court may not be taking up these issues, and certainly has to be incredibly persuasive in order for the court to decide to take one up. I also think as a state litigator, it puts some pressure on the sort of cases that states do try to bring under original jurisdiction. If so many members of the court are concerned that there will be too many of these cases and in effect states will not be able to self-moderate, then I think it really puts a spotlight on what sort of cases states are bringing. And I think that that's going to be a really interesting practical consideration, no matter which side of the line you fall on, whether you think states should have to justify that these states should go to the court. I think practically that's something that remains to be seen as these number of cases continues to grow.
Great, thanks, Lindsay. That's very helpful and interesting to explain something that people might not have noticed in those orders lists. So I want to turn to our next topic, and as everyone on this webinar will be familiar with, in Massachusetts versus EPA, the court kind of famously said that the states are entitled to special solicitude when it comes to asserting their Article 3 standing to get into federal court. But if you've been reading the decisions from this term, you might wonder if that's actually true. So Stephen, I'm wondering if you can talk to us about two cases that the court heard and decided this term in which the court found that the state plaintiffs actually lacked standing, and what you think we should take away from those cases.
Sure. So the two cases I'll discuss are Trump versus New York, which we were involved in, and then Texas versus California, which I think many of us on this meeting were involved in. So Trump versus New York was a case where several states and localities had challenged a policy announced by the prior administration to exclude undocumented immigrants from the apportionment base that is used for congressional redistricting. As I think most people know, the census is conducted every 10 years, and then the population figures for every state then determine how to allocate the 435 seats in the House of Representatives between the different states. Now, historically, apportionment has been based on every single person found by the census. So the prior administration's policy would have excluded undocumented immigrant populations, and I think the argument was differentially affected the states that had larger proportions of their population that consisted of the undocumented immigrant groups. And that apportionment injury was the basis, or at least was one basis, for the state standing to bring that. The Supreme Court sidestepped a very interesting controversy over whether it was permissible to exclude undocumented immigrants by saying that at the time that the states had brought their suit, and at the time the Supreme Court issued its decision in December, that it was quite uncertain whether the administration would or would not actually be able to exclude undocumented immigrants, and to what degree. And so it said it didn't present a justiciable controversy at that time. And I think what the court pointed to was a variety of representations, as well as other facts that had come out really during the course of the litigation, showing that, one, the Census Bureau was having enormous difficulty just conducting the census at all. I think it's very difficult to count every person in the country in ordinary circumstances, and COVID-19 had made that very challenging for the Bureau for this particular round of the census. But the other thing that had started coming out through leaks from the Census Bureau, as well as through the administration's own representations, was that the Bureau was finding great difficulty figuring out who was undocumented from both the administrative records and others, and hadn't yet estimated exactly how many people they could find and how many people they could therefore exclude. And so the court pointed to all of these uncertainties as a reason to say it was inappropriate for the court to reach the merits question in that case, which is whether that policy was permissible at all. The coda to this litigation is that the court's sort of concern that the Bureau may not actually achieve the announced policy turned out to be correct. I mean, over the next month, the Bureau did not in fact release final apportionment figures at all, let alone figures that excluded the undocumented population. And then with the change of presidential administration, there was a revocation of the policy to exclude the undocumented population. And so the whole dispute sort of went away as a result of that. The other case I want to discuss is Texas versus California. And this was, again, another major case where the potentially earth-shaking substantive issue was ultimately avoided by a jurisdictional ruling on standing. So this was the case that Texas and other states had brought, and it was billed as threatening the validity of the Affordable Care Act. I think as most people remember, the court in NFIB had held that the individual mandate in the ACA, or the minimum essential coverage provision, it had upheld that provision as a valid exercise of Congress's tax power because it imposed a tax penalty, but rejected it as an exercise of the Commerce Clause power. So what's important for the Texas versus California case is that in 2017, Congress revisited the ACA and reduced the tax penalty in the minimum coverage provision from several $100s to $0. And Texas and other states returned to court to say that that change rendered the minimum coverage provision unconstitutional again, because it removed the tax penalty justification that NFIB had relied upon and made it again just a bare mandate for people to engage in commerce, which is not something that the states contended Congress could do. So, and I think the consequence of that, according to the states, was that the entire ACA, or at least significant portions of it, would have to be invalidated as well, because they were inseparable from the minimum coverage provision. The Supreme Court again sidestepped this debate, including the severability issue, by saying that both private plaintiffs and the states lack standing. The private plaintiffs lack standing because the minimum coverage provision, the court said, was unenforceable. It was a $0 penalty. So they weren't really affected by the fact that there was a bare command out there that didn't really have the force of law behind it. And the states also lack standing, I think, for two reasons. I mean, one, the court said the states hadn't shown that the $0 penalty would change people's behavior in terms of enrolling in state-operated medical insurance programs. And this is premised on the same point that because it was unenforceable, it didn't sort of affect private behavior. And then second, the court rejected the argument that the ACA as a whole, because it was inseverable from the minimum coverage provision, imposed administrative costs on the states. And the majority concluded that that harm came from provisions of the ACA that the states hadn't independently challenged as unconstitutional. Instead, it came from this minimum coverage provision, and so rejected that sort of causal chain as a basis for state standing.
Thanks, Stephen. So I'm going to pose this to all of the panelists, but I'm curious whether, knowing about and listening to Stephen's description of these two cases, whether our panelists think that this kind of special solicitude that states get has been cut back on, or whether these cases are kind of one-offs, as Stephen kind of hinted at, maybe that the merits were impacting the standing decision in some way.
So I'm happy to start very, very briefly. I think it's hard to say at the moment. I think there are definitely features of both of these cases that make them seem unique. But I think there's a couple of things that we can draw from. I mean, one is that whatever special solicitude the states might have, the court in these two cases is obviously taking a somewhat harder look at assertions that the states have made about future injury in the census case or the apportionment case, or about present injury traceable to some federal statute or regulation in the ACA case. And exactly what form that more searching inquiry takes is a little hard to tell, except that I think the court has adopted a pretty practical approach to deciding whether, in fact, it believes, or certain members of the court believe, that states are experiencing practical harms from some program that they are challenging. But I think, as all of us have seen, and maybe others can speak about as well, the lower courts have been a little bit all over the place in terms of standing, both before these decisions and to some extent afterward. And I don't know if there's any trend lines yet that have emerged, so much as conflicts that may result in the Supreme Court revisiting the issue in the near future.
Thanks. Did any of the other panelists want to chime in on this one?
I can jump in quickly. I mean, I agree with everything Stephen just said. I guess I've always wondered what exactly special solicitude meant here. And as Stephen says, the lower courts have been kind of all over the map. These cases probably don't help us figure that out. Massachusetts versus EPA was a case where, Massachusetts was claiming the harm that it was claiming was that it was literally losing state land. Doesn't seem like you need a lot of special solicitude to find standing on that theory. And so I do think we've all struggled at various times in various ways to figure out what work that does and what that means, other than maybe in close cases, the courts will be deferential, ought to be deferential to the states. But as these cases show, that there are also cases that may be close to some people where the courts are still going to engage in some real review of what the state's asserting.
And I'll just jump in briefly. I think one of the interesting things we can see from these cases is that the Supreme Court seems really concerned about the practical side of standing. And that's interesting because there can be a perceived disconnect. These cases can involve such huge issues, huge constitutional issues, but then to read a court decision that's focusing on literal dollars and cents for state agencies and programs, that disconnect can be a little bit jarring, I think, especially for non-attorneys who are reading some of these cases. But it's an interesting question for us as state litigators, because in other contexts, when we argue, irreparable harm, for instance, often the violation of a right or, not enforcing a duly enacted law can be construed as harm to the state. But we don't really see the Supreme Court going in that direction. So I think this disconnect between the rights that are being litigated and the way that we get into court in the first place to establish standing, whatever it means, and I agree, I don't think we know what it means, but I think we're seeing that divide widen.
Great. So brief administrative interlude to give our attendees the CLE code, which is USS C21, and it's going to be in the chat too. And with that taken care of, I want to talk a little bit about administrative law issues now. So over the past few years, we've seen a number of cases in which the court invalidated a federal agency action as arbitrary and capricious because it wasn't adequately reasoned. Examples that come to mind include the rescission of the DACA program and the proposed addition of a citizenship question on the census. This term, though, the court upheld an agency action on arbitrary and capricious review. So, Lindy, I'm hoping you can tell us what happened in this case, FCC versus Prometheus Radio Project, and tell us what you think we should take away from this case.
Certainly. So I'll give a disclaimer first. Like many of these admin law cases, they have many lives before they get to the Supreme Court. And I was involved in private practice in one of the earlier iterations of this case. But to speak briefly to what this case was about. So the FCC has a series of ownership rules that limit the number of radio or TV stations or newspapers that can exist in any given market. And there's a specific statutory command that every 4 years, the FCC has an obligation to review all of those rules and then repeal or modify any that are no longer in the public interest. So this case involved a decision in 2017 where the FCC decided to repeal 2 of its rules and to modify 1 of them. It determined that they were no longer necessary in the public interest and said the record did not support the idea that repealing these rules was likely to harm minority or female ownership in any of these areas. This case was first up in the Third Circuit, and that court vacated this decision and remanded with direction for the agency to determine, based on record evidence, the specific effects on minority and female ownership. And then it went up to the Supreme Court. This was a 9-0 decision reversing the Justice Kavanaugh decision, and the court held unanimously that it was not arbitrary and capricious for the FCC to make the changes it had. And one of the interesting things about this was the fight over the accuracy or sufficiency of the data in the administrative record. There were real questions about, was there enough information to reach a firm decision on this question of effects on minority and female ownership? And even the FCC had admitted in this litigation that there were gaps in that data before it. One of the interesting things the Supreme Court said is that it's not the agency's job to basically find its own evidence here. It doesn't have to commission studies or statistical research on these questions, and it's simply okay to rely on what is or isn't in the record. So the effect of this in this case is that it's a rule that seems more in favor of deregulation or more generally in favor of a changed agency position, because in some ways it could be viewed effectively as shifting the burden to the commenters in the notice and comment process to disprove the agency's proposed rule rather than putting the burden on the agency to support it through the evidence in the record. So I think when it comes to what does this mean going forward, it's the same question we've had come up a couple of times before. One of the issues is going to be, is this a this case only case, or does it have broader implications? One of the arguments it could be this case only is that particular statutory requirement that I mentioned earlier, that the FCC has a statutory duty to revisit these rules and make a determination whether to repeal or modify them every 4 years. So the argument could be that here the statute does tip the balance in favor of deregulation, and so maybe these administrative law provisions don't apply more broadly outside of that particular context. But it's interesting, we've seen that argument before about whether these administrative law and record-based questions are for this case only or not. You know, the DACA case, for instance, that Kirti mentioned, there's been a lot of commenters who said the discussion about the record and reliance interest that's really focused on those particular circumstances. But as I know, we'll talk a little bit later in the shadow docket, just recently the Supreme Court cited the DACA decision when it came to the denial of the stay and the remain in Mexico policy. And so that was a critical reason in its analysis for likelihood of success. So maybe this decision does have more life further on. So I think the broader point is that it remains to be seen what will happen here, whether this is really a larger trend towards holding agencies more accountable towards what's in the record or not. I think from a litigation perspective, at minimum, it puts more pressure on the notice and comment process, because it's important under this decision for commenters to get evidence in the record if it is true that the agency doesn't have this general obligation to build up the record itself. And if you combine that with some of the decisions like the DACA case we saw, maybe the court is going to be a little bit more skeptical of the way the agency responds to the evidence that is there. So either way you cut it, I think that means that the record that commenters, individuals, states, other parties put into the record is more important in that case. And I think the other thing these cases do is it sort of brings the elephant in the room into focus, that agencies have a lot of power, and it doesn't surprise any of us when they make major policy changes when a president from a different party is in the White House. So I think we're seeing the way that the court is acknowledging that and trying to figure out what does it look like with a broader doctrine going forward. And it raises a lot of questions of how do we think about regularity in the administrative law process, reliance interest in big policy changes or structural accountability, the role that Congress should or shouldn't play. And I think the takeaway here again is it remains to be seen what the answers to those questions will be. But the court has definitely added another interesting piece to that puzzle.
Thanks, Lindsay. I'm sure the court will have plenty of opportunities to help us answer some of those questions over the next couple of years. But let's now talk about one case that the court has already granted for next term, which is an administrative law case. So Ben, can you tell us about American Hospital Association versus Becerra and what's at stake in that case?
Sure. So the question in this case is how much HHS will pay hospitals under Medicare to reimburse them for certain drugs. And I know that as soon as I said Medicare and reimbursement, I probably lost half of the audience, but stick with me. I'll try to make it interesting enough. So the statute says that the reimbursement rate for these drugs is the average price for the drugs plus 6%. But it has a provision that says that HHS can adjust that amount, quote, as necessary for the purposes of this paragraph. And really what this case is about is how much flexibility does that give HHS to make adjustments? What happened in this case is there's a group of hospitals that for various reasons are entitled by law to discounts from drug manufacturers, and they get like a 20 to a 50% discount depending on the type of drug. And so HHS said that if we pay those hospitals the average price rather than what they actually are paying for the drugs, they're getting an excess reimbursement for what their costs are. So they adjusted the price as necessary for the purposes of this paragraph by saying we're going to pay you the average price instead of the average price plus 6%. We're going to pay you the average price minus 22.5%. It's a huge difference. It's $1.6 billion that turns on this question. From hospital sued saying you can't do that. And in particular, they pointed to there's another provision of the statute. It's the one that's the subsection right next to this one that says that HHS can base its reimbursement rates on cost rather than price, but only if it does certain surveys that HHS hasn't done to determine the average costs. HHS says, hey, the statute says we can adjust this as necessary for the purposes of this paragraph, not over reimbursing hospitals is a legitimate purpose, and so we can do that here. And the DC Circuit upheld that, applying Chevron deference to HHS's approach. I think what's most interesting about this case is the cert petition, and the Supreme Court has granted cert. The cert petition was all, about Chevron deference front and center. It said Chevron deference is out of control. This case is a perfect example of it. Just allowing HHS to do whatever it wants and courts kind of not taking a hard look at it and just saying, well, seems reasonable enough. And they really pitched, they didn't quite say the Supreme Court should overrule Chevron, but they framed this case as an opportunity for the court to cabin Chevron deference in various ways. The U.S. had never really relied very heavily on Chevron deference. I mean, it is in the DC Circuit's opinion, but the U.S. had been somewhat reluctant to invoke Chevron deference here and had barely mentioned it in its briefing. And so now that cert was granted, the hospitals just filed their opening brief a couple of weeks ago. They still talk about Chevron deference, but it's like 3 pages at the very end of the brief. I mean, this has become a kind of straightforward statutory construction case. They, as in many of these cases that potentially involve Chevron deference issues, the hospitals are saying the statute's unambiguous. It says you can use costs, but under these circumstances, these aren't those circumstances. Therefore, whatever else this means, it doesn't allow HHS to base reimbursement rates on costs. And so I don't know whether the Supreme Court took this case in order to potentially make some broad pronouncements about Chevron deference, or whether they took it just because there's a lot of money that turns on this, and it was a divided decision in the DC Circuit. But there's certainly a number of ways that the court can resolve this one way or the other without touching the bigger Chevron issues. There's also a reviewability question about whether another provision of the statute prevents judicial review of these reimbursement rates. So I guess with so many other things we've said today, I guess we'll see. But it could be a significant case about the future of Chevron deference, or it could not turn on that at all, no matter which way it comes out.
Yeah, it's interesting. I think this case might be an example of, there's the certiorari stage when you pitch a case to get the court's attention. You might frame a case differently than when it comes down to the merits and your sole goal is kind of, achieving the best outcome for the client that you're representing. And it sounds a little bit like maybe there was some shift in the framing in this case, but that kind of speaks to a question of whether, Ben, you think that this court is interested in administrative law generally, and that's part of the kind of bucket of issues that it wants to hear cases on in the next few years. We've talked a little bit about religious liberty. It's very obvious the court is interested in that. Is administrative law one of those areas?
I think it is. I think you still, as with any other area, you need the right case, and you need an issue that is itself important and interesting enough to get the court's attention. But there's no doubt that the justices are thinking about some of these bigger questions, like the extent to which it's appropriate for a court to defer to an agency's interpretation. We saw a lot of discussion of similar issues in Kaiser versus Wilkie a couple of years ago about Auer or Seminole Rock deference, the extent to which a court should defer to an agency's interpretation of its own regulations. There was real ideological division, I think, among the court as to how to approach that question, with a couple of justices saying, a lot of this theory maybe doesn't really make a big difference in practice. And you might be able to say the same thing about Chevron deference, that there's a lot of interesting theory to be worked out there, but how much of a difference will it really make in practice to the way courts approach these cases? I don't know, but there's no doubt that there's several justices who are interested in it. And maybe it's a good strategy whenever you have an administrative law issue involving Chevron to say, this case gives you an opportunity to revisit the fundamentals of Chevron. But if you get too many of these bait and switch approaches where it gets briefed differently on the merits, I think the Supreme Court may wise up to that.
Thanks, Ben. So we talked about hard look review. We've talked about Chevron deference. Do any of our other panelists think there's kind of a classic ad law issue that they expect the court to take up in the next couple of years? Okay, if not, we'll go right into an issue that all of you were involved in. So I expect at least one of you will have something to say about this. So everyone in this panel is involved in some way in a set of petitions that are before the court that involve the legality of the Clean Power Plan and the Affordable Clean Energy Rules. And so I'm hoping one of you will take the chance to tell us what the kind of administrative law stakes of those cases are, aside from the kind of environmental policy stakes of the cases.
Well, I can start us off on this one. As Kirti mentioned, all of our states are involved on both sides of the V on this case. So I'll give a brief view of what the case is about, and then my views of what some of the admin law issues could be at stake if the court takes it up. So in a nutshell, this is about the scope of EPA's power when it comes to setting systems of emission reduction for certain power plants. And the question is, generally speaking, does EPA's power under the statute, is it limited to the sort of controls or practices or technology that can be applied to a particular source to run more efficiently or more cleanly? Or can EPA look at a more system-wide level and move towards a generation shifting policy that affects where and what type of energy is produced around the country? So certainly has huge consequences in terms of climate environmental issues, but certainly energy issues too, where regional differences really matter in terms of the type of energy that's available to the residents of our different states. So moving on from the more controversial parts about the merits there, quickly what I think some of the admin law issues will be. One is just sort of a big picture issue of how is the court going to approach changing rules when you have different administrations changing. So this is a case where the cert petition is after the second of the major rules in this case. There was one, the Clean Power Plan rule under the Obama administration, and then the repeal of that rule with the Affordable Clean Energy rule under the Trump administration. And now the Biden administration has said that none of the things that have gone below, we're not going to reinstate the previous rule, we're going to do something different. So it'll be interesting to see how the court views that in terms of its doctrine about the sort of cases that are appropriate for review. As the lead state and a state coalition urging review, I think it will surprise no one that I think that the court should take up this case. I think there's an argument that it is important to see in a case like this, what are the ground rules? Who gets to make the decision and how far do they go? But there's also the argument on the other side that Stephen and others proposed in their briefs, that is it really worth it for the court to take up this case if there's going to be a new rule going forward? And this is an issue that is not limited to this case. It comes up all the time where we see changes of big policy issues like this. It'll be interesting to see how the court approaches it. And then more briefly, I think it'll be, if they do take it up, there'll be this question of how closely is the court going to read the operative statute? How much leeway is the court going to be giving the agency when it comes to these Chevron issues versus more of a pure statutory interpretation issue, as Ben was discussing? I think that's an interesting question we may have here. And another issue is looking more broadly. Are there questions that are simply too big for us to assume that Congress meant to delegate them without very clear language? That's what some of the justices have referred to as the major questions doctrine. That's one of the issues here, is how clearly should we expect Congress to talk about decisions that could have consequences for the entire country or for broad sectors of the economy? And if the court does recognize and affirm that doctrine more, what sort of things would count to be major? So are there things that are of economic or politically charged significance? Are they areas that are traditionally areas of state regulation or not? So if the court does take up this case, there's certainly some really interesting questions we could see for the development of admin law.
And I can speak briefly on this as well. I think one thing that's interesting about these environmental cases is how they highlight how the agency's choices affect the way that the court ends up reviewing the rule in question. I mean, for the Affordable Clean Energy rule, the EPA had actually sort of adopted this position that they were relying on what they viewed as an unambiguous restriction in the statute. And therefore, it wasn't about Chevron at all. It was just, what did the statute say? Was it super clear? And I think part of the challenge that some states had brought was to say that, well, their reading of what was unambiguously prohibited was not correct because it was either incorrect or not unambiguous, and therefore should be rejected. But again, that was a choice the agency, I think, made for itself in deciding what it wanted to rely upon and how it wanted the court to rule. And I think, as Lindsay was saying, we will see agencies adopting very different positions on the threshold question of whether they should admit that there's an ambiguity in the statute, how broad that ambiguity is, and what they rely upon and the factors for deciding how to sort of make different choices about a rule based upon the scope of that ambiguity. And so I think there's like a threshold question that agencies will run into all the time about it. But the other thing I think is interesting here, and something that I found sort of fascinating in the course of litigating all these cases, is as everybody knows, these rules can run to like hundreds of pages, sometimes thousands of pages if you take into account technical documents, responses to comments. And I think there's always this urge during litigation to try to find clear lines to draw, because you only have, a couple dozen pages to brief these. You don't have usually thousands of pages to respond to everything the agency has said. And when the agency is either in classic Chevron land or is in arbitrary and capricious territory, I think that really highlights this sort of puzzle about where either the agency tries to hang its hat or where a litigant coming in points to some fundamental error that might be on 2 pages of a 500-page document as a basis for either upholding or reversing the agency's decision. And I don't know right now whether there are like clear principles here to do that. I think sometimes these things become clear during the course of notice and comment rulemaking. And so I 100% agree with what Lindsay said earlier. I think notice and comment rulemaking is a way for interested participants to define the contours of the debate. But other times, I think skillful litigants are able to sort of focus people's attention on particular aspects of a rule. And so focus the Chevron inquiry or arbitrary and capricious inquiry on certain features that take on added importance during the litigation. And sometimes by the time it gets to the Supreme Court, you've seen years of work to get to that point already. So anyways, I just think that's an interesting feature of these complex cases, that they evolve from the time they are proposed in the Federal Register to the time they finally get to the Supreme Court.
I know this is it's a big set of petitions, so I want to make sure that Ben and Mithun have a chance to chime in if they want to, but no pressure. Okay, great. Well, so let's turn to another kind of big issue, which is one that Mithun hinted at earlier, the shadow docket. You know, I think when most people think of the shadow docket, to the extent they know what it is, they think of recent orders related to COVID and religious liberty-based exceptions to COVID orders, or they think of you know, death penalty stays, or more recently, the abortion litigation that the court heard. But there was a recent report by A&E News pointing out that, you know, like every area of the law almost, there's an environmental law angle to this too, which is that the court has previously addressed big environmental policies like the Clean Power Plan through the shadow docket. So I think, you know, it's helpful for people interested in environmental and administrative law to know what's going on the court shadow docket. And so Mithun, there have been 2 recent administrative law related issues that came up through the shadow docket, one related to the Remain in Mexico program and one related to a series of orders related to the Biden administration's eviction moratorium. So can you tell us about those cases and what the court did in them and what you think the significance of those cases is?
Absolutely. So yeah, the shadow docket no longer in the shadows as much. In the last month, over 3 dissents, the court allowed a lower court judgment to go into effect that held that the CDC's eviction moratorium during COVID exceeded the CDC's statutory authority. Again, that was over 3 dissents, and then also over 3 dissents, they last month allowed a judgment reinstating Trump's Remain in Mexico policy because allowing it to go back into effect because the Biden's repeal or attempt to pull back that policy was arbitrary and capricious or inadequately explained, citing, interestingly, the decision under the DACA case. You know, both of these cases, in a certain sense, come on different postures. They're both allowing lower court judgments to go into effect. One was vacating a stay of the lower court judgment, and the other one was just allowing the judgment, so denying a stay of the lower court judgment. And I think it shows you why the shadow docket's not going away, because there are always going to be people from all sides asking the court to exercise its power. And so when they act, either deciding not to stay or deciding to stay, they're going to get criticized one way or the other. So, you know, when they acted, like in the eviction moratorium case, they get criticized. When they don't act, like in the Remain in Mexico case or the recent challenge to the Texas abortion law, they also get criticized. And so, unfortunately, for better or worse, it is part of the court's docket, and especially in the era of COVID, when we saw a lot of these things related to, you know, shutdown orders, especially as applied to religious organizations. There are cases that are going to need quick resolution, and the court's got to decide whether or not to grant that sort of quick relief one way or the other. And I say it's not going away, nor should it go away. partly for selfish reasons, because all of us here may at one point have or will have asked for shadow docket emergency orders. I did earlier this summer and received one in an Indian law case on a criminal matter, and over 3 dissents. So we all actively use a shadow docket. And I actually think that there may be a decent argument to be made that the increased prominence of the shadow docket may have started with the Clean Power Plan stay. It may not have been as apparent of and as nationally important of an issue as it had been since the Clean Power Plan stay. But I think the court's latest shadow docket ruling, one that happened just early, I think last week, may show an interesting development as far as a potential path forward to deal that the justices may be using to deal with the controversy surrounding the shadow docket. And this was in an execution case that Kirti mentioned as one of the typical areas where the shadow docket arises. And this usually deals with emergency applications to stay or stop an execution. And here it was about Texas's prison policies about when and how clergy can be allowed in the execution chamber. And this has been something that's been percolating in the court for the last couple of years through a series of shadow docket orders. And last week, the court granted a stay, so a shadow docket decision of the execution for a Texas prisoner who wants his pastor to be in the execution chamber and be able to lay hands on him and audibly pray in the execution chamber. But instead of just leaving it to a shadow docket order, they also granted very expedited review of the case. So taking it out of the shadow docket and into the merits docket, but accelerating it given the expedited nature of the issues. So what we might be seeing is a court shifting from a shadow docket cases to a rocket docket, as some people have called it, allowing for greater briefing and merits determination and full-fledged arguments and opinions, but also accommodating the oftentimes emergency natures of these requests.
And, one question is, before where we want to track the start of the rise of the shadow docket, whether it's the Clean Power Plan or before or after, states like the Solicitor General's Office of the United States are repeat players. And so the conventional wisdom had been, maybe don't go to the court in every case, hold your fire and save it for the big cases. But we saw during the Trump administration, there were more requests directed at the Supreme Court, and those requests were often granted. So I'm curious whether you think that the states, maybe we've already seen it, or maybe we will see that the states might be going to the court more, and what kinds of considerations the states might be thinking of in terms of when to use the shadow docket and when to litigate a case over time.
I think this is definitely
any of our Mithun or any of the
that's fine. I'll be brief so I can allow other folks to jump in. I think this is definitely a symptom of the larger issue of the rise of administrative law and a lot of policymaking happening in the administrative law space instead of through legislation. And so, one can see that the Trump administration did go up often, but they also were faced with many more nationwide injunctions of Trump administration policies than prior administrations. So it's hard to figure out what's the sort of chicken and egg on these issues. But I certainly think that states realizing that a lot of national policy making is happening at the administrative level, and therefore more likely to be decided on the judicial level, since those are potentially more subject to more difficult judicial review than statutes, that you're going to see it happen more often. And as much as states don't want to be seen as asking for it too often, as often as these lower court decisions, which are having big public policy impacts, are happening, may dictate how often states are going up to the U.S. Supreme Court about it.
And I'll just add briefly, I do think that there are some downsides to the shadow docket. I agree that it's unavoidable. There will always be emergency requests and people will make them. But I think one thing, and this is hopefully bipartisan on this, is that, one of the challenges of the shadow docket is it's hard to interpret sometimes what the Supreme Court is doing. Sometimes it issues like a single line stay order. It's almost impossible to divine what the justices are thinking or will be thinking. And it's sometimes worse if they have like a short order explaining some but not all of their reasoning, because then, everybody's sort of like poring over like six sentences or 3 sentences and trying to decide what it means for litigation. And it causes a lot of problems, afterward, which is maybe one of the reasons, as Mithun said, they granted this rocket docket petition in this most recent case. But I think it's also one of the things that may not be apparent to people too, is that part of the reason for this is that it's very challenging for the litigants to be responding to these shadow docket cases. I mean, I think, we all believe we're experienced and good litigators, but, we get the call from the emergency clerk saying that we have 24 or 48 hours to respond to an emergency application, or when we feel the pressure to file something because of an imminent harm that's happening the next day or two, that really restrains our ability to identify the right issues, make the right arguments, even present the right question to the court. And I think that combination, the sort of lack of guidance from the court and the difficulty for the litigants in framing the issue, has, I think, posed some problems with the shadow docket that I don't know there's an easy answer to, except maybe just avoiding it altogether and going straight to somewhat more protracted merit review.
And I would agree with that. I mean, I think we are all saying that I think the shadow docket is unavoidable. We all have clients, whether it is our state or, very often one of our agencies. And I think the shift we're seeing in the Supreme Court says it's going to become part of good lawyering in order to pursue these options. But one of the things that I'm interested in following is, what does it do for the evidence at stake in these cases? There's just not enough time to develop the record here. And so much of what we've talked about before are areas where the Supreme Court may be taking a harder look when it comes to the support for standing, or when it comes to particular record-based arguments. And often these stay requests, one of the factors is likelihood of success on the merits. So when we have these dual trends of the Supreme Court looking in some cases to be more exacting about this, but we're moving on such a quick pace where we're not able to build those records. I'm very curious to see what that does, if anything, to some of these broader decisions we're seeing, because so often, even though the emergency piece may not be the entirety of the case, as Stephen was mentioning, in some ways it can really shape the way that the case goes forward, the sort of arguments that are raised, certainly the public perception of the case. So what does that do with the speed, and are we losing more than we're gaining? I think there's a lot that remains to be seen there.
I guess I'll just add, I agree with all the comments that have been made about the inevitability and the pros and cons of the shadow docket, but I do think there's a perception out there that the bar has been lowered for what the Supreme Court will take seriously in a stay application. I can think of cases, including a case that my office was involved in, where states are seeking emergency relief and obtaining emergency relief, where I'm not sure we would have even thought to try 5 years ago, 10 years ago. Maybe that's a good thing, and maybe it's not, but I certainly think what we've seen over the last few years has changed my perception, and probably other lawyers' perceptions of when it is worth making an application for emergency relief to the Supreme Court.
Thanks. So let's turn to the question and answer portion. We have time for a couple, and we've gotten a couple already. But one of them was about Prochaski, the nominal damages case, and what impact that might have for states. It does seem to potentially open up more plaintiffs' ability to get into suit or get into court. So I'm curious whether any of our panelists have views on that opinion and how important it will be going forward.
Yeah, I think this is one of the more significant standing decisions of this term, and it's Uzugbunam v. Prochaski. Told you this wouldn't be the last weird name I'd say, and I know I'm the last person to complain about hard to pronounce names. And it's a big deal for state and local governments. It held that persons bringing 1983 claims can seek nominal damages for violations of their constitutional rights, and that satisfies Article 3 standing, even if there are no other live claims in the case. And so, if the government ends up doing something that you claim is a constitutional violation, but it doesn't necessarily cause you any tangible harm in the sense of monetary harm, you can still bring a nominal damages claim in addition to any claims you have for declaratory and injunctive relief. And even if the government changes its mind about its policy and repeals a policy such that your injunctive claim is now moot, you can still continue your case because you have a nominal damages claim. And this is important because, this actually kind of happens oftentimes. And we saw it, and I'm sure Stephen can talk more about it, in the New York pistol and rifle case, where certain folks were challenging a New York regulation under the New York gun regulation under the Second Amendment. And in the midst of the litigation, the New York repealed its policy and therefore mooted the case, and the court dismissed the case as moot. But, one of the issues there was, well, they didn't bring a nominal damages claim. And now that we know that that is sufficient for standing, it'll make it less likely that these cases can go away by the government changing the challenge policy.
We had another question related to the shadow docket, which I think should be a quick one, but the question kind of raised the issue of whether there's some strategy to use the shadow docket in cases where maybe you want to focus the review on statutory questions rather than record review, because maybe the record hasn't even been produced yet. So I'm curious whether any of our panelists think that there's some strategy involved on the shadow docket.
Yeah, it's interesting. I wonder if it's less of a strategy and more that, I think we've all had experience where somebody brings a claim that is framed in a certain way. And then in the course of the district court proceedings or the appeal, either additional facts come out, or sometimes we representing our agencies discover things about the program that materially affect the way that the question is presented. And this is what Lindsay was saying. When you see the speed with which these cases go through, especially the Supreme Court, you lack the ability for development to show that there is actually like a different way of looking at the dispute, or maybe undermining either the states or the private plaintiff standing, or changing the remedy that might be available. I don't know if people are relying on the shadow docket to prevent that kind of an inquiry, but it is, I think, an unavoidable consequence of the fact that, especially at the appellate level, you don't have the same flexibility you have in district court to actually change the contours of the case.
Okay,
And
great. Sorry, go ahead, Lindsay.
Oh, thanks. And I would just add briefly on that. I think watching what happens after the eviction moratorium case is going to be an interesting corollary to this question here, because there we had the court who just said, clearly the statute doesn't allow this sort of thing. And there's an argument that, with more facts here, that could have been a more complex issue. So I think in some ways we see members of the court trying to do this. And certainly in terms of it's framed in a different way. So I think in terms of looking at strategy, we have to see perhaps what some of the justices are doing and how they're framing these cases too.
That's great. Thank you, Lindsay. And I'm going to toss it back to Bethany for a wrap up, but I just wanted to say thank you to all of you. I definitely learned a lot listening to all of you, and the perspective of folks like you who are litigating these issues every day is incredibly interesting and valuable.
Thank you, Kirti, and thank you, Ben, Stephen, and Lindsay. It was so interesting listening to you discuss these issues. It was fascinating for me, even though I, was helping organize. So thank you so much. And Kirti, thank you for facilitating this fascinating discussion between states that are sometimes on different sides and just really bringing out really interesting points. Thank you also to our co-sponsor, the State and Local Legal Center. We're dropping a link to the evaluation form into the chat, so please fill that out. And you'll be getting your CLE credit if you can, you'll be getting the form to fill out for CLE credit. So please keep a lookout for that. Thank you all so much for being here, and thank you so much to the panelists and to Kirti for moderating. Really appreciate it.